So the fight over the future of suppressors and short-barreled rifles under the NFA, just got even more interesting. Not only did the federal court here handling the Silencer Shop NFA challenge just schedule oral arguments for later this month, and they also revealed the exact constitutional questions that it wants answered in that litigation. But now a second major NFA challenge has just been transferred into the very exact same court. And that transfer may be more significant than people realize, because the judge handling the Silencer Shop case is already examining whether the NFA can survive after Congress reduced the tax on suppressors and SBRs to $0. And now another challenge raising some of these same questions and some different ones as well is being funneled into the same courtroom, which means one federal judge may soon be evaluating virtually two of the biggest constitutional arguments and challenges against the modern NFA. So let's break down what just happened in this case. Now, before we jump into this video, if you want to support the channel, one of the best ways to do that is simply by subscribing. You can also hit the like button. That just tells the algorithm that you appreciate this content, and so it shares it with more people. So if you've been following the channel for a while, you will know that this all started after Congress passed the One Big Beautiful Bill, and in that law, they changed the NFA making and transfer taxes on suppressors, short-barreled rifles, short-barreled shotguns, and AOWs, and they changed it from $200 to now $0. Now that immediately created a constitutional question and opened the door for some of these legal challenges. Historically, courts upheld the NFA because it operated as a tax statute. The Supreme Court repeatedly described the NFA as an exercise of Congress's taxing powers. But if the tax is now effectively $0, can the federal government still require a registration, fingerprints, approvals, federal databases, and also felony penalties if you fail to comply? That question is now being litigated in multiple lawsuits across the country. The largest of these is the Silencer Shop case that was filed in the Northern District of Texas with various 2A organizations, and that one has been moving forward very quickly. Recently, in the Silencer Shop case, the court has officially scheduled oral arguments on these pending summary judgment motions, and that will happen later this month on June 25th, so very soon the court will consider this issue. And this is important because the case is now moving beyond procedural disputes and directly into the constitutional issues themselves. But the hearing date isn't the biggest development in that case. In fact, the biggest story is what the judge did when he ordered and set those arguments. The judge issued a detailed order laying out the specific constitutional questions that he wants both sides to prepare to answer during those arguments. The court specifically wants to know whether the NFA's registration requirements for untaxed firearms can still be justified under Congress's taxing powers. The judge is directly asking whether registration can survive after the tax has now disappeared. That is the exact argument the plaintiffs have been making since the beginning of this lawsuit. The court also focused heavily on the DOJ's newest defense of the NFA. As we've discussed recently, the federal government has largely shifted away from defending the NFA based on the now zeroed making and transfer taxes. Instead, the DOJ argues that the registration system remains constitutional because it helps enforce the special occupational tax, which is paid by certain NFA businesses. The judge specifically ordered the parties to explain whether the registration requirements actually aid in collecting that occupational tax and whether that issue is a question of law, fact, or some combination of both. That is significant because it shows the court understands that the occupational tax theory may be the government and the DOJ's primary remaining defense for the NFA now that the tax for the making and transfer is $0. What's especially interesting is the judge in this Silencer Shop case is not limiting this case to just the taxing power question and arguments. The court also wants briefing on major Second Amendment issues that were raised. The judge specifically asked whether short-barreled rifles should really be treated the same as short-barreled shotguns under modern Second Amendment doctrine. The court also asked whether suppressors should receive constitutional protections as functional components of firearms, similar to magazines and other necessary firearms accessories. These are huge questions because they could potentially create independent grounds for striking down portions of the NFA, even if the taxing power claims actually fail. Now, here's where things are getting even more interesting. A completely separate NFA challenge that we've covered in the past, known as Jensen versus the ATF, has just been transferred by Judge Kaczmarek into the very same courtroom handling the Silencer Shop case. The The Jensen case raises many of the same constitutional challenges. The plaintiffs argue that the NFA's registration requirements can no longer be justified after Congress reduced the tax to $0. They also challenge the NFA under various Second Amendment, as applied challenges to suppressors and short-barreled rifles. And what's fascinating is that the reason that happened here for the transfer, Judge Kaczmarek explained that both lawsuits substantially overlap and that those constitutional issues should be resolved in a uniform manner. The court specifically stated that placing both cases before the same judge allows that judge to evaluate all of the legal arguments being presented and helps to ensure a consistent outcome. Now, that's very important because the court isn't treating these lawsuits as isolated disputes, and he does not want conflicting opinions. The court is effectively recognizing that they are part of a broader constitutional fight revolving around the NFA. Strategically, this may actually benefit the plaintiffs going forward. The silencer shop case has focused heavily on the taxing clause, the necessary and proper clause, the new precedent in the Fifth Circuit in the McNutt case, and the government's occupational tax theory. Jensen also contains additional Second Amendment arguments directed at suppressors, SBRs, and the NFA registration system at large. Now, all of those arguments are effectively heading towards the same court and potentially also, and very likely, the same judge. Instead of multiple courts reaching potentially different conclusions, one court may now evaluate all of the strongest constitutional arguments all together against the NFA. So stepping back, the biggest takeaway of what just happened is that the Northern District of Texas is rapidly becoming the central battleground for the post-$0 tax NFA litigation. The court is not avoiding the merits of this issue. The court is not dismissing these challenges. The court is actively asking whether the registration can survive without the tax and if the NFA also violates the Second Amendment. And now additional NFA challenges are being funneled and directed into the same courtroom. And that's potentially very good, especially since the judge in the silencer shop case, who will likely also get the Jensen case, appears to understand all of these issues and is taking this NFA challenge very serious. So the court handling the silencer shop challenge has now scheduled oral arguments and revealed the exact constitutional questions that he wants answered during those arguments. At the same time, Judge Kaczmarek sent the Jensen challenge to the same judge, to the same courtroom, to be reviewed because he believes it overlaps and it's so substantially similar that the same judge should also consider that case as well. And that means that one federal judge may soon be evaluating two of the biggest and major challenges against the NFA after Congress reduced the tax on suppressors and short-barreled rifles. So the upcoming hearing in the silencer shop case, which happens on June 25th, is now looking even more important, and it will be interesting to see what happens now with the Jensen case since it's heading to the same court. And as soon as we get more filings, as we get an update on the Jensen case and potentially also the silencer shop case, if that transfer of Jensen impacts the silencer shop case at all, I will let you guys know. If you like this video and you'd like to support the channel, one of the best ways to do that is simply to like, comment, and subscribe. All of those things help to fuel the algorithm and just tells the algorithm that you appreciate this content, and so it shares it with more people. But as always, thank you so much for all of your support, and never forget this nation was built by armed scholars, and this nation will be maintained by armed scholars.